In the Rahimi case, SCOTUS said that someone could be temporarily disarmed if they pose a danger to themselves or others. How about denying someone their gun rights for life for writing a bad check? Let's go ahead and talk about it. What's up, Wolverines, and welcome back to my little piece of the internet known as John Crump News. My name is John Crump, and I want to expand the work that I do to keep the ATF on their toes, and you can help out. Check out my locals or Patreon that is listed below in the description. Also, like the video, subscribe, and share it out. Costs you totally nothing, and it really does help with the channel. Now let's talk about what is going on. In 2008, Melinda Vincent was homeless and fighting drug addiction. She was desperate. When people are desperate, they usually don't make the best decisions. She decided to try to write a fraudulent check for $498.12 at a local grocery store. Not the best move, and she did get caught. She could have faced a fine of $1 million and been sentenced to 30 years in prison, but luckily for her, she was just placed on probation. She totally turned her life around since then, though. She became a mother and a social worker. She also started the Utah Harm Reduction Coalition, which is a nonprofit. Basically, she is the person we hope that all people suffering from addiction become. But guess what? The check fraud is a felony. It isn't a violent felony, and she doesn't have any history of violence in her past, but it's still a felony. Under a 1961 federal law, she is prohibited from buying firearms, and she really wants a gun to protect her family. She sued in 2020, but a federal judge at the district court level dismissed her case in October of 2021. That was before the Bruen decision that changed everything. After the landmark decision came down from SCOTUS, she decided to appeal the dismissal. Bruen is very specific. The courts can only use the original text, tradition, and history of the Second Amendment to determine if a gun law is constitutional. She believed that the federal government would fail to prove their case and fail to prove that the law is constitutional. Let's go over the 2 steps of the Bruen test. Step 1, is the law consistent with the original text of the Second Amendment? A well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Is Miss Vincent part of the people? Let's dig into that a little bit. The courts say that the people are the political class. The political class are those who have reached the age of the majority. The age of the majority in the United States is 18 years old. So she is definitely part of the people. She is also trying to get a gun, and a gun is a protected arm. That means her conduct falls under the plain text of the Second Amendment, and her conduct is presumably constitutional. That is her burden to prove, and she did that. But that's the easy step to prove. Now the burden shifts to the federal government, and they must prove that a law is consistent with the history and tradition of the nation's firearms regulations from the founding era. Most people believe that the founding era is the ratification date of the Second Amendment, which is 1791, although some on the anti-gun side claim that it is actually 1868, the ratification date of the 14th Amendment. The state does have to prevent historical analogs. According to the Rahimi decision, a historical analog doesn't have to be a historical twin, but it does have to be remotely similar. And speaking of Rahimi, we call that foreshadowing because that's going to come into play in a little bit. In September of 2023, a 3-judge panel from the 10th Circuit Court affirmed the district court's decision. Ms. Vincent immediately asked for an en banc hearing. That hearing was granted. An en banc hearing means that the 3-judge panel's decision is vacated like it's never happened, and the case is reheard by the entire 10th Circuit bench. In June 2024, the en banc would affirm the district court's ruling. Ms. Vincent's lawyers would file for a writ of certiorari with the Supreme Court. A writ of cert is a petition to the Supreme Court to hear a case. During that time, the Rahimi case was heard by SCOTUS. The High Court ruled that someone could be disarmed temporarily if they are a danger to themselves or others. The The key words are temporarily in danger to themselves or others. There is nothing to suggest that Miss Vincent is a danger to herself or others. And 17 years doesn't seem so temporarily to me. SCOTUS would GVR the case in light of Rahimi. A GVR is a term that you might hear a lot. It means granted, vacated, and remanded. SCOTUS grants cert, vacates the lower court's decision, and remands the case back down to the lower courts to be reheard again, in this case due to Rahimi. Basically, SCOTUS is giving the lower court a chance to fix anything that is inconsistent with the Rahimi ruling. That was a good sign because there's no way the 10th Circuit would think Miss Vincent is a danger to herself or others, right? Well, there are a lot of case history recently of circuit courts disregarding SCOTUS and doing what they want to do, even if it goes against the SCOTUS ruling. And I believe this case is one of them. Given this remand, we freshly considered the Second Amendment claim and conclude that Rahimi doesn't undermine the panel's earlier reasoning or results. That is exactly what the 10th Circuit said. I highly disagree with that, but that's what they said in their 6-page decision. How could they come to this conclusion? Well, they did something sneaky. They cited a case called U.S. v. McCain that said that felon deposition laws are presumably valid. Your next question is, how is that allowed under Rahimi and Bruen? Well, I hate to tell you this, but this case is from 2009, well before the Rahimi or Bruen decisions. Personally, I don't think this case is valid anymore, but the 10th decided to use it as their basis for their ruling. I think if McCain was heard today, it would fail because of Bruen and Rahimi, but the 10th Circuit used that to come to the conclusion and rule against Miss Vincent. We are seeing more and more courts ignore SCOTUS, even though SCOTUS is a superior court. Activist judges. SCOTUS needs to smack these courts down once and for all. A good way for them to do this is to immediately grant cert to any of the cases they GVR'd and fast track them back up so SCOTUS can hear them and issue an opinion that is consistent with their ruling. That would be great for the people affected by this injustice. There is a judicial coup going on in this country, and I think it's high time that SCOTUS lays the smackdown on these activist judges' candy asses. Yeah, I did quote The Rock.